What is capitalization or capitalizing a business entity, what we often call handling the capitalization matters? Well, to begin with, most business entities will form, and after formation, they will need to be funded or bring in some sort of value into the business so it can begin to operate. Often, this is done through the contributions of the owners of the business. It may be a contribution of time and effort working in the business, or it may be a contribution of money or other physical assets that have value, or intellectual property that has value. With that being said, this is known as capitalizing the business or capitalization matters. Now, we are going to look at the situation where individuals are giving value into the business in exchange for an ownership interest in the business. And this process generally begins with a subscription letter. The subscription letter says that it recognizes the intent of this future purchaser of an ownership interest, this future shareholder in a corporation, this future member of an LLC, that they intend to transfer value to the company in exchange for an ownership interest, and lays out some preliminary terms along those lines. The agreement by which you exchange ownership interest for the value provided is the subscription agreement. This is the contract through which you exchange value, by which the shareholder becomes the owner of the interest and the company receives the value from the shareholder. Oftentimes, this transfer of ownership comes with the delivery of physical stock certificates. If the company does not print or create physical stock certificates, the ownership interest will simply be recorded in the company's books. Now, oftentimes, because the value of whatever interest you receive in the company, this is particularly true when you receive an ownership interest that vests over some future period. Generally, this is attached to a service agreement where the individual is going to provide value to the company over time working for the company. You'll want to make sure when you receive an ownership interest that is subject to this vesting period that you'll make the election up front that you are saying, I have received this value even though ownership has not yet vested in me. The reason for this is to record that you are receiving the value at the current value, not at the value at a later time when it's probably worth more money. So it reduces your tax obligation, but you have to affirmatively make this obligation in order to elect to be taxed, if at all, on this value at this time. Again, it is a tax planning method, but it is a very important step in the capitalization process for individuals subject to the vesting of their ownership interest. Okay. Oftentimes, once this is complete, it requires security filings. Now, generally the Securities and Exchange Commission of the United States, together with state-level securities bodies, will regulate the sale of an ownership interest in a business. And there are all sorts of hoops, if you will, to jump through in order to do this in accordance with the regulations and laws. With that being said, generally, if you are going to seek an exemption from registering your security with the Securities and Exchange Commission, then you will have to give the Securities and Exchange Commission notice of the selling of an ownership interest in your business, and you'll have to send in what's called a Form D, perfecting this exemption from registration. You have to file this form within 15 days of actually selling an ownership interest. So with that being said, it's important that these regulatory steps are taken as part of the process. It is very important to work closely with your legal counsel to make certain you stay in compliance with these legal requirements. Okay. Oftentimes, capitalization, instead of issuing an ownership interest immediately in the company, it will issue stock options, or the ability to purchase an ownership interest in the company at a future date. If the company uses a stock option plan, it will need to be approved by the board of directors prior to distributing any stock options. And when you do, once again, you will record the value of the options at the current time. Usually it requires an annual valuation for tax purposes and accounting purposes. So this is the subject of a different, longer discussion, but stock option plans are setting aside a percentage of your ownership interest that is subject to options that you are selling the options to others is an important part of the capitalization plan. Anyone who is going to purchase an ownership interest in the company or stock options should be made subject to what is known as a buy-sell agreement or buy-sell provisions. Oftentimes these are present within the subscription agreement or present within the bylaws to which any purchaser of an ownership interest is subject. So with that being said, a buy-sell agreement simply makes certain that the company has control over who will own this ownership interest. And if an individual wishes to sell their ownership interest in the company, that the company has rights or first rights of refusal or offer to purchase back that interest before it can be sold or traded to anyone else in a separate transaction. Consent to service generally means that the shareholder is giving consent for how information or notice about their ownership interest can be delivered to them. So all of these taken together generally make up what constitutes capitalization matters. There are tons of intricacies that go along with each of these steps, these undertakings, but this is the general outline of what a company will undertake when capitalizing initially the business.